This is the resumption of meeting number 27 of the House of Commons Standing Committee on Procedure and House Affairs, which started on April 13th, 2021. Today is May 25th, 2021 at 11 a.m. Today's meeting is taking place in hybrid format pursuant to the House Order of January 25th, 2021, and therefore members are attending in person in the room and remotely using the Zoom application. The proceedings will be made available via the House of Commons website. And so that you are aware, the webcast will only show the person speaking rather than the entirety of the committee. So far today, we don't have anyone attending in person, so everyone is attending virtually. So just a reminder to raise your hand using the tool function, which is located at the bottom of your screen. And no taking photos of the screen or screenshots, just a reminder to everyone about that. And other than that, I guess we always need the reminder to mute and unmute ourselves because somehow we all tend to forget that. And remember also, which I hadn't done, to turn your translation on too if you need. So before speaking, please wait until I recognize you by name. And I do have a speakers list. We are on Ms. Vecchio's motion. And for that, there was a speakers list since we suspended last time. That speakers list is Ms. Shanahan, and then Mr. Turnbull, and then Mr. Blakey, who wishes to speak. He also, Mr. Blakey also informed me just before the meeting that he'd like to report on some developments, perhaps. And so just so everyone has that in mind as well, that there may be some new information that could hopefully progress movement in this committee. And so we'll hear what Mr. Blakey has to say. But first, I will hand it back to the speakers list. And Ms. Shanahan, you are first on that list.
Merci beaucoup, Madame.
Thank you very much, Madam Chair. It is a real pleasure for me to be here with my colleagues today on PROC, especially because I heard my colleague, Mr. Thériault. He was talking about the Fête des Patriotes, Patriots' Day. I think everyone knows that in the other provinces, yesterday was Victoria Day, but for us here in Quebec, it is a day to recognize the role of the Patriots, and I'm always very proud of this celebration. I have nothing against Queen Victoria. She even played a very important role for our Patriots exiled to Australia. She is the one who pardoned them after 5 years, because the Quebec Patriots, especially in our region, well, these were merchants, notaries, doctors, etc. These were educated and very devoted individuals, patriots who were fighting for responsible government. That was their ideal, because this rebellion in Lower Canada and in Upper Canada was not spontaneous. At that time, there was the British colony, there were British governors in place, and society, Canadian society, was developing. Canada was Lower Canada, and people were demanding certain things. Chenier, Nelson, and others were demanding justice, governance, responding to citizens' needs. People were still British citizens, But British citizens had rights, the right to be represented in Parliament, and they were entitled to sit in Parliament. So we were claiming the same things, demanding the same things here. Historians tell us that the reprisals were much more serious for the Patriots here in Quebec. Some people were even hanged, lost their lives. Others were exiled to Australia. A very difficult 6-month-long journey. They were sent to Longbottom, a penal colony in Australia. But the fact that these were educated, peace-loving people, people who were reasonable, in Australia, it was British authorities that were responsible for the penal colony, and these French Canadians were forced to work. But when the authorities realized that those men were educated, well, little by little, they granted them different tasks, administrative tasks, and even a role in governance. Still today, Madam Chair, we can see the influence, the impact of those Canadians in today's Australia, because after 5 years, they were well settled in. They worked for merchants. They worked for governors. They asked to be pardoned. They worked to be able to pay for their trip back. And most of these Canadians did return to Quebec, despite the fact that the governor had said, listen, if you'd like to stay, we'd like you to stay. We'd like to keep you here. There is one gentleman, Mr. Marceau, who stayed on, and he and his descendants contributed to the establishment of Australian democracy. It's an incredible story that was recounted by someone from here, Mr. Le Bailleur, who came back to Quebec, but who put pen to paper and wrote down this history. Mr. Duke Richards documented all of this in a publication celebrating this democratic link between French Canadians and the development of the Australian Parliament. How should I say this? Thanks to this tragedy, because it was very sad for those involved, for the Canadians exiled to Australia. But thanks to them, we can go to Australia to visit Canada Bay, Chateauguay Walk. Chateauguay is here in Quebec, and we have a museum dedicated to the Patriots here in Chateauguay. And there's also Boulevard Marceau, or Marco, because Mr. Marceau had 11 children in Australia, so he really greatly contributed to Australian society. And he was a very important man in the history of Australia. So all of this to say, Madam Chair, that this was an important principle, that of responsible government. And I believe that that is what is at the heart of what we're discussing here today. Namely, how we must ensure that in every situation, the government of the day remains responsible and accountable to the Canadian people. And how do we accomplish this? Well, indeed, when there's an emergency situation, when there is a development that changes the landscape, For example, an election, a major change in the economic situation, a change to the economic situation, well, then we use this instrument called prorogation, and it becomes an instrument to put forward the new plan of the government in place. It's an opportunity to ask parliamentarians representing all Canadian citizens if they have confidence in the government. So, Madam Chair, I think I've already told you that I'm an amateur historian. My first BA was on the history of Quebec at the University of Chicoutimi. And I remember this. It was back in the 70s. Those were exciting times in the history of Quebec, as we all remember. But our professors showed us that it wasn't always the big events led by great men. At the time, people said that it was always great men who determined the evolution of society, but it's a story of men and women in all of society's sectors that generates activity, and the very raison d'être of people. And they determine whether or not it is legitimate for them to be governed by these great men and great women, because indeed I recognize that in the British Empire, it was Queen Victoria, Queen Elizabeth first before her, and now we have Queen Elizabeth II. It's interesting that during the most important periods in the history of Great Britain, the country was led and governed by a woman. But that's an issue for another day, perhaps, and perhaps even another committee. Nevertheless, I would like to come back to this instrument called prorogation. And we see that this motion that has been before us since April, the motion we have before us now, well, it questions, it asks why the government opted for prorogation in August 2020. And it's not the first time that I've spoken about this motion, but it's not a bad thing to question one's reasons. That's perfectly valid, because we've seen in the past that sometimes the government has been questioned with regard to prorogation. Why did it prorogue?
Dans laquelle on gouvernait a vraiment changé, c'est-à-dire l'économie ou la sécurité publique, un pandémie, n'importe quelle autre raison importante qu'on peut voir, qui peut arriver, ou est-ce que c'est pour des raisons purement partisanes? Donc, c'est la raison pour laquelle que notre gouvernement, que quand on est entré en pouvoir, on a mis en place
Excusez-moi, Madame la Présidente.
I'm sorry, Madam. So sorry. I'm in French and I hear English interpretation of what Brenda said. I'm sorry, Ms. Shanahan. That's okay. I don't know. Maybe we had to check. I heard the English translation, whereas I was listening to French. Mr. Terrien, this is the clerk. I think it's okay now. the bad channel was selected here in the room.
Excellent.
Okay, well, thank you, Mr. Terrien, because it's really a pleasure for me to be able to speak about the subject, not just the motion before us, but to talk about the whole history of the evolution of our Parliament. This is not just a piece of paper we have to direct us. This is a whole evolution. But to get back to what was done to better manage this instrument of prorogation, what was said was that the government, be it the House Leader or any other person, once the Prime Minister has made the decision to prorogue, it's the government itself that must explain within 30 or 60 days, if I'm not mistaken. Anyway, it has to have a written report. I know that I discussed this during another speech because I found it so complete. I was really able to go through it to demonstrate that the report that was presented in the House, as it should be, to demonstrate to the House, here are our reasons, because the vote had already taken place, a confidence vote on the throne speech. The opposition had an opportunity to show that it was dissatisfied, that it did not have confidence in the government. So the vote had taken place. The report was tabled. The report was made public. But some are not satisfied with that approach. And so here we are at the PROC Committee, Procedure and House Affairs, to examine a motion that was tabled by Ms. Vecchio that seeks to discuss anew and review all the reasons for prorogation. Without getting into the whole debate on the amendment tabled by Mr. Turnbull, which in my opinion was perfectly reasonable, took the original motion and made suggestions to adjust it, to keep the essential parts and make it acceptable to all members present. But the opposition did not accept that amendment. We could have come to an agreement. We could have responded to the essential parts of what colleagues from opposition were seeking and wanted to examine, and get on with what's important. The fact is that we still have a pandemic going on. We're still in a situation where we have to manage that pandemic, and at any time, since if the opposition had voted against the throne speech, we would have been in election mode right now. Without having safe measures in place, which are completely justified to try to manage this situation. In September 2020, it was certainly very serious, and that remains very serious today, even though we're so glad, Madam Chair, that we've gone beyond 50% vaccination. In Quebec, it's going extremely well. People are very happy. I just talked to many people over the weekend. But people are still maintaining distance, but neighbors and people walking in the street, we cycled a bit. People are glad. They're happy with what's happening. But nevertheless, they told us, Madam, we don't want anything crazy to happen. Nobody wants to go backwards here. So I can say that, to my mind, coming back after a nice long weekend, having celebrated our historical heritage, we had beautiful weather. We have some idea of what's coming. We're going to come back to normal life. We're at the same point as where we were a few months ago with Ms. Vecchio's motion. And I think I'll stick to remarks on the motion because I think I've already discussed paragraph A. But when I see what the other paragraphs contain, I can tell you, Madam Chair, that I have a lot to say regarding each one of these paragraphs. But as I said, I'll keep that for later. And with that, I will close. Thank you very much.
Shanahan, if I can just, there's a couple of things I felt I should have probably said at the beginning of the meeting. Just as a refresher, because we were all on a constituency week as well, we have had Bill C-19 referred to the committee as of May 11th. So it's been some time. I mean, we had the constituency week in between, obviously, which took the time up. This is a government bill, so there's no time limit for the committee to consider the bill, but generally legislation is given priority by committees. And some of the things that I think if the committee chooses to move forward on that, things we'll have to keep in mind are we would need to decipher how many witnesses to have, which witnesses, dates for those witnesses. Those suggestions need to be sent to us, just to keep all that in mind so that we can schedule them because there are always scheduling difficulties. So we need to know that stuff as soon as possible in order to complete any said, if we wish to make any amendments to the bill. And then we would need to determine a date for clause by clause and basically an overline deadline of that. And another reminder to the committee that the next meeting, today is the 25th, so the 27th would be the last date in order for us to consider the main estimates. Otherwise, on the 31st, they will be reverted back to the House. So just a reminder on the main estimates as well. And I will move on to Mr. Turnbull and then Mr. Blakey right after that.
Thank you, Madam Chair, and I appreciate your reminder about Bill C-19 being a government bill. And I think, how those usually, I think, take precedent in committee business. or at least I think that that's the informal practice that's generally followed. So I hope that the committee today will see some movement to Bill C-19. That's my hope. So I'm stating that outright. It might be because we had a constituency week, but I'm coming back to the committee with renewed optimism, a little bit of sun on my face, and I don't know why. That's just invigorated me. I'm looking forward to today's meeting. It's good to see everybody. I appreciate Ms. Shanahan's comments. I actually especially appreciated, the story she told about the significance of a holiday that I think exists differently within a different cultural context, and I appreciate that very much. I thought that was insightful. Also appreciated you speaking to the amendment, even though we're not on the amendment, just that I had put forward, which was an attempt to appease some of the opposition parties and hopefully move forward. I know we voted that, the committee voted that down, so I won't cover anything to do with that today. But listen, I did want to just frame where I think we are as a committee quickly, and then looking forward to hearing from Mr. Blakey. I think, and I've said this multiple times, but I really think it's important to emphasize that from the very beginning of this particular conversation, which started a long time ago, we agreed to study prorogation as a committee, and we heard from witnesses. We heard from quite a number of witnesses. And I think the government in general has been very transparent when it comes to prorogation. And I've said from the beginning that, if a global pandemic is not a good enough reason to prorogue Parliament, then I don't believe any reason will satisfy the opposition parties. And I really, truly, I have to keep stating that because, I really feel that that's the grain of truth here that I'm holding on to, that eventually the opposition parties are going to realize that, given a global pandemic, given a government that's being as responsive as possible, that there was a need to reevaluate and reset the agenda. And that's exactly what happened. Now, I've argued and argued and argued for this point over and over and over again, and I'm not going to go through all the data and evidence that I've provided for how the throne speech reflects all the consultation work and the incredible data gathering that happened during prorogation. I already got that the opposition parties, as far as I can tell, don't care about that argument. They're not listening to that reasonable, I think, explanation, which is, to me, a rational explanation that makes perfect sense, given the context of a global pandemic. But I also want to just speak to the fact that, from my perspective, we're now debating a motion on We Charity. So, if you look at Ms. Vecchio's motion, it has the Kielburgers, the Honorable Bill Morneau, Katie Telford. It's got the Perelmuters and the Speakers Bureau. It's got requests, massive, huge document requests that would have to be produced and translated. We Charity is mentioned multiple times. The section F and G of her original motion specifically reference We Charity. So there's absolutely no doubt, or there can be no doubt out there of anybody watching or anybody on this committee that the motion is to try to connect We Charity to prorogation as some ulterior motive that I think opposition parties have been trying to prove. And we heard from witnesses, some of them speculated, most of them I think said, well, there's always a potential political motive for prorogation throughout history, and that there are always slightly multiple narratives on why prorogation happened. But most of them also claimed that, given a global pandemic and the context, it actually is a pretty good reason to prorogue. What I find strange, though, is that we're still stuck on this motion when after, the Conflict of Interest and Ethics Commissioner's report has come out. So I took a little time over the week that we were in the constituency, and I had a little time in the mornings and in between meetings. And so I read a good portion. I don't think I poured through every single page, but I read a lot of it. And I found it really interesting to see the analysis that was done by the Ethics Commissioner, Mario Dion. And so what I would say is what shocks me and surprises me is that the Prime Minister has been completely exonerated by that report of all counts that the opposition parties have been claiming over and over and over again, taking up committee business in other committees. Fine, I got it. They wanted to, quote unquote, hold the government accountable, which is what opposition parties are supposed to do. So I got that. But at this point, at this juncture, at this moment in time, we're still in a global pandemic. Opposition parties are voting against the government, in many cases coming dangerously close to triggering an election. And yet they don't seem to be willing to move on to study Bill C-19, which would ensure that Canadians can vote safely, that their health and safety would be protected, and their democratic right would be protected if an election were triggered. So I'm still just feeling like, can we just face reality here? The reality is the We Charity supposed scandal is not a live topic anymore. It's a closed book. It's a closed book. Like the ethics commissioner reviewed all the evidence and data. They reviewed it. I'm going to read you the conclusions here, just in case people haven't taken the time to read that document. So there's three major sections of the Ethics Code or the Conflict of Interest Act that were said to be, the sections that were pertinent to the study that was done or the report that was written. Section 7 is one that prohibits public office holders from giving preferential treatment to a person or organization. Now, the Ethics Commissioner, and this is in the executive summary, so just read the quick conclusion. I can go into more detail if people want, but I don't think that'll be necessary per se. But the evidence, so this is on page 2, the evidence also shows that Mr. Trudeau had no involvement in ESDC's recommendation that we administer the CSSG. I am satisfied that Mr. Trudeau did not give preferential treatment to we. So that's one conclusion, okay? Now, the other section, subsection 6.1, prohibits public office holders from making or participating in the making of a decision that would place them in a conflict of interest. So this one as well, the Ethics Commissioner concludes, I am satisfied that there was no opportunity to further Mr. Trudeau's own interests or those of his relatives from WE's role as administrator of the CSSG or from its social entrepreneurship proposal. That's one conclusion. There's another one related to this. WE's private interests would have to have been furthered improperly. In my view, there is no evidence of impropriety in relation to Mr. Trudeau's decision-making in relation to WE's social entrepreneurship proposal or WE's administration of the CSSG. Those are two quotes that demonstrate that there's clear conclusions, that the evidence has been reviewed, that, like this is the Ethics Commissioner we're talking about who's done their due diligence and found and ruled that the opposition parties, and I know that this is disappointing to the opposition parties because they wanted a scandal out of this, but there is none, okay? There is none, and the Ethics Commissioner's report is very clear. The other section that I would just quote quickly, section 21, which requires recusal only in instances where the public office holder would be in a potential conflict of interest. So this one as well, the Ethics Commissioner says, section 21, this is a quote, provides that recusal is required only in instances where the public office holder would be in a potential conflict of interest. So I therefore found that Mr. Trudeau did not contravene section 6.1, section 7, or section 21 of the Act. So now just take a step back for a second, please, committee members. I'm appealing to your better interests here. Take a step back. Okay, months and months and months, opposition parties have been trying to claim that prorogation was tied to We Charity. if now we have conclusive evidence and all the due diligence has been done that now says there was no conflict of interest, and the conclusions are clear based on a really in-depth assessment of all the evidence and facts, then how can we possibly continue to debate a We Charity motion on this committee when we have business that this committee needs to attend to protect the health and safety of Canadians? And tell me, do you feel, members of this committee, that that's responsible for us to do? I want to ask you to, as all of us are responsible for this work to continue forward. We have a government bill that's been referred to our committee, Bill C-19. We need to get on with studying this bill. That's my plea to you. I don't know how we can not face reality and really debate this whole We Charity and prorogation link. It's non-existent. If there was no conflict of interest, does it even make sense for opposition parties to try to tie the two together? It doesn't even make sense anymore. So give it up and let's move on to C-19, please. Now, I want to move that the committee proceed to study Bill C-19.
Okay. Thank you, Mr. Turnbull. Mr. Clerk, can you help us with a vote on that, please?
Yes, I will, Madam Chair. Dr. Duncan. Oh, you're on mute, Dr. Duncan.
Sorry, can the question again, please?
I apologize. The question is on Mr. Turnbull's motion to proceed to another order of the day, which would be Bill C-19.
I support.
Madame Petitpas-Taylor.
Oui.
Mr. Turnbull.
Yes.
Monsieur Lauzon.
Yes.
Mr. Morrissey.
Yes.
Ms. Vecchio.
No.
Mr. Nader.
No.
Mr. Lakiski.
No.
Mr. Kent.
No.
Monsieur Terrien.
No.
Mr. Blakey.
No.
Madam Chair, motion defeated 5-6.
Okay, thank you, Mr. Clerk. We will move next to Mr. Blakey.
Excuse me, before we get started, I'm sorry, Daniel, before we get started, I'm beginning to have it's Karen over here, having a technical challenge because I can't get my video on. So I just wanted to let you know that I'll mess around with it, but I don't know if you can see anything in the room.
Yeah, when you voted, it kind of went on for that moment, right? Okay.
Oh, my video. There we go. Maybe it's going to work this time. Nope. Anyway, I will just continue to play with that, but just an FYI. Okay. I'm playing.
Mr. Clerk, can we have somebody from the tech team call her?
Ms. Vecchio will have an IT ambassador reach out to you to try to assist with the problem.
Okay, thank you. Ms. Vecchio, just want to confirm you can hear us, though?
Happy Joyful. I'm on the other end. Yep.
You can hear us, right? Okay, perfect.
Perfectly.
Okay, Mr. Blakey, go ahead.
Thank you very much, and wishing Ms. Vecchio the best of luck in correcting technical difficulties. I had one of my own this morning, and that certainly has been a frustrating feature of virtual parliament. So I hope you're able to get that sorted out. I thought I might begin by just addressing some of the comments that have been made already this morning. And I'll start with Ms. Shanahan. In terms of responsible government, because I took the gist of the argument that Ms. Shanahan was making to essentially mean that if opposition parties don't vote to have an election in the face of things that they don't like about the government, that means that there's nothing to criticize or that the government can do whatever it wants. It effectively has carte blanche until opposition parties decide to trigger an election. And I want to propose to Ms. Shanahan that I think that's has an important misunderstanding of the principle of responsible government. I mean, we have question period, we have committee work, we call ministers to committee. We've got all sorts of tools to interrogate the government about its courses of action. And we do that because there are more than one way to hold the government to account. And in fact, sometimes an election is exactly the wrong way to hold a government to account, particularly if you're trying to focus in on specific decisions of the government. Because I think, as we all know at this table, elections are very general affairs, and there's a lot of kinds of issues that come up in an election. There are many kinds of issues that preoccupy, rightly, the attention of voters during an election. And while voters may be very dissatisfied with the government in respect of some of their decisions, that may not ultimately be the vote determining issue. But just because a particular instance of government wrongdoing isn't the ballot question at the ballot box doesn't mean that the government's behavior is justified. It doesn't mean that there isn't still a need to hold government to account. And in fact, that is the function of Parliament. The function of Parliament isn't to cause elections. The function of Parliament is to hold the government to account between elections. And so there's a number of mechanisms that have been developed in order to try and do that, including calling ministers to testify about decisions that they've made before committee. What's been tying us up hasn't been the fact that the opposition refuses to call an election. And I think even in ordinary times, it's not clear to me that that would be the right solution for this particular scandal. What's been tying us up is that government members haven't been allowing a committee to proceed in using some of the normal tools of accountability in order to hold a decision maker to account for something that they've done. And in this case, the thing that they did, that he did, the Prime Minister did, was prorogue Parliament. I think in the wrong way for the wrong period of time, which is not to say that it was wrong to prorogue at all, but we've heard that there are different ways to do a prorogation. There are different periods of time. And we've heard very clearly in a number of ways that that was ultimately the Prime Minister's decision. And we have heard, as Mr. Turnbull indicated earlier, that that's a decision that is often political all the way down. And I think that means that it stands to reason that members of Parliament would care to interrogate the only decision maker about his political reasons for prorogation. And what's at issue is whether the predominant concerns had to do with the pandemic or whether they had to do with getting out of the political heat on the We Charity scandal. And the only person that can answer those questions is the Prime Minister. So nothing untoward has been going on here at committee with opposition members supporting a motion to get the Prime Minister and a number of other players who were involved in what is also quite plausibly a major reason, not just for the prorogation itself, because I agree there can be multiple reasons for prorogation. Often in government, there's more than one thing going on in a decision. In fact, the art of government, arguably, is to balance competing demands and competing interests. And very often when government makes a decision worth taking note of, it's because it is complicated, because there are a number of things at play. But I do think, it is quite reasonable, even if the We Charity scandal wasn't the only reason for the prorogation, that it affected the nature and duration and timing of that prorogation. And that's fair game. The only person that can really settle that question for the committee is the Prime Minister. I submit to you that the Government House Leader did a bad job of that. And people are free to disagree with that. I'd love to hear from the person who actually made the decision. And I really don't think that was unreasonable. So it's just not something that I can accept, first of all, that it's been unreasonable to insist on hearing from the principal decision maker in respect to a file. And the last time Ms. Shanahan spoke to responsible government prior to today, I tried to highlight for her some of the ways that a decision about prorogation or dissolution is a special, this is the language right out of the Order in Council. I'm not making up new terms. Since 1935, at least, decisions about prorogation and dissolution have been a special prerogative of the Prime Minister. That is something that by Order in Council, that is by a decision of the entire cabinet, has been set aside for the Prime Minister to make alone. And that's in keeping with the Prime Minister's special role as an advisor to the Crown. And I mean, there are many people, I'm sure, who would have loved to have been in the meeting in one controversial prorogation I can think of, where Prime Minister Harper of the day met at length for hours with the Governor General on the eve of a prorogation. And there was some debate in the lead up to that meeting. And in fact, during the many hours of that meeting, live on radio and the 24-hour news cycle and all that good stuff that politicos, watch with fascination in times like that. There were lots of people who would have loved to have been in the room. The government house leader wasn't in that room. Staff from the whip's office weren't in that room. I'm not even sure that the Prime Minister's chief of staff was in the room. That was a meeting between the Prime Minister and the Governor General. And to me, that just highlights the nature of that special relationship and the nature of the special decision-making authority of the Prime Minister and the extent to which nobody can stand in for the Prime Minister when it comes to decisions having to do with either the prorogation or dissolution of Parliament. So I thought that that was important to state if I haven't been clear enough about that in the past. And I don't think that that's a viciously partisan interpretation of the facts. I actually think that's pretty good. I think that's pretty good exegesis of parliamentary process and a little bit of parliamentary history for that matter. And the idea that when the opposition is dissatisfied, responsible government calls for an election is a broken idea, and it's broken at least because it would mean that we have no responsible government in majority parliaments. I think that's a pretty clear implication, because if responsible government demands that the opposition trigger an election anytime they think there's something seriously wrong with the way the government has behaved, and they don't have that power in a majority parliament, then that means we have no responsible government in majority parliaments. I'm sure that was not what Ms. Shanahan intended to imply. That would certainly shed a different light on the last parliament, I would think. Although I could appreciate if some people wanted to maintain we didn't have a proper kind of responsible government in the last parliament, I doubt it would be Ms. Shanahan and her colleagues in the Liberal Party. I'm happy to be corrected on that point at any time if someone would like to claim otherwise. And so those are some things that I think are important to say. In respect to Mr. Turnbull's comments, I would say this, the issue about the timing and the nature of the prorogation are important to me for a couple of reasons. They're important, as I've said before, because there was a pending deadline for CERB, and millions of Canadian households were depending on that program and didn't know what was coming down the pipe. The government made an announcement about what they intended to do at the end of CERB the day after prorogation. That is to say, they chose when to prorogue, they chose when to announce that package, they chose to announce it at a time that there could be no meeting of Parliament for parliamentarians to ask questions in the House. We had another scheduled summer session. In fact, it was going to be within 7 or 8 days of the Prime Minister announcing that prorogation. And I can't for the life of me in any of the testimony that we heard or any of Mr. Turnbull's best arguments see why that prorogation couldn't have at least waited until the day after the last scheduled sitting of Parliament in the summer. Those 4 sittings of Parliament were negotiated among the parties, recognizing that there was a pandemic, recognizing that there was an important role for Parliament, not just the government, but for Parliament during the pandemic. And the Prime Minister unilaterally decided to break that all-party consensus, to have Parliament play that role, and to cancel the last scheduled sitting of Parliament in the summer. I think that was a serious mistake. I think he did something wrong when he did that. So I am not satisfied by the answers of the government House leader as to why, not that there was it's not an on-off switch, prorogation or no prorogation. The Prime Minister also made decisions about when to prorogue. And I want to ask him about those decisions. And I do believe that the We Charity scandal and trying to protect himself and his government from that fallout played a role in the timing of the prorogation. And I'd like an opportunity to press him on those issues. because I think they matter. I think it matters that an all-party consensus to have Parliament meet bi-weekly during the summer was unilaterally quashed by the Prime Minister. And there would still have been weeks for the government to consult when Parliament wasn't scheduled to sit. So why was that last summer sitting canceled after the work of getting all the parties of the House on board? That was something that was done, if I recall correctly, by unanimous consent. So not only were the recognized parties on board, but that meant that the independent members and members of the Green Party also supported that consensus. I don't think it was appropriate for the Prime Minister to act against Parliament in that way. And that's the way I see it. And frankly, that's not something that's been really addressed in the hours of debate that we've heard from Liberal members. Nobody has spoken directly to the issue of why the prorogation had to occur on the day that it did. And that's fine. I don't really care to hear Liberal members opine about that because I know who made that decision. It was the Prime Minister who made that decision. So I'd love to hear the Prime Minister opine on that. I'd love to hear him give his reasons, not for prorogation in general, but for prorogation on that day and why he saw fit to upend a unanimous decision of the House of Commons to meet twice in August, 4 times overall over the course of the summer, and why he would choose to cut that sitting off to announce the package for the replacement of CERB, which was likely to be controversial in the non-pejorative sense of that term. That is to say, I think it was very reasonable to expect that there would be different opinions about what that would look like from the various political parties, and that there would be some discussion required in order to get to something looking like a consensus. So why take away the opportunity for parties to question the government about what that consensus might look like, with enough time for that actually to be hammered out, not at the 11th hour when households are wondering what the heck they're going to do next month if they can't make rent, but to actually do it progressively over the course of 4 or 5 weeks, or at least to have an initial conversation on the record that allowed the parties to stake out their preliminary positions and thoughts on what the government's proposal was. So to me, that's a matter of significance, and it cuts to the question of how the Prime Minister handles the prerogatives of his office: dissolution and prorogation. And it's quite topical. I mean, I know Liberals want to say everybody's moved on. There's still people, incidentally, who are upset about the We Charity scandal. If you don't hear much about them, then I think the Liberals should at least do a little more listening in Western Canada, where I'm from, because I certainly hear about it. And I know that's a common criticism of the Liberal Party, that they don't listen enough in Western Canada. So maybe it's just a regional thing. You guys aren't hearing it. But if it's the case that Ontario's moved on, and I doubt that too, it's certainly not the case that people west of Ontario, I can tell you, have moved on from concerns about the We Charity scandal. But there's also, as I say, just the question, it's topical, even if people have moved on from the We Charity scandal, which I say I don't think they have. What they haven't moved on from is wondering whether we have a Prime Minister who's going to act unilaterally to call an election at a time that Canadians really don't think that we should. Now, I've been part of efforts to demand an answer from the Prime Minister on this. The NDP's asked very openly in the House whether the Prime Minister will commit to not calling an election unless he actually loses a vote of confidence. And I've seen him sidestep that issue repeatedly. So if Canadians don't have confidence in the Prime Minister's ability to use that prerogative well, then I think having him at the committee is an opportunity for him to better explain how he used the prerogative of prorogation. And that might give Canadians some insight into how he intends to use the prerogative of dissolution. It's very much a topical conversation because those two powers are intimately connected. They're both mentioned in the Order in Council from 1935 that I made reference to earlier today and in my remarks the last day of the committee meeting. So we are very much in a time where Canadians have every right to wonder at the way in which the Prime Minister uses those special prerogatives of his office. And I think examining his decision on prorogation is an important part of examining his use of those special prerogatives overall. So again, I don't think this is a viciously partisan argument. I think it's actually pretty straightforward. I think it makes a lot of sense. And I think that, you know, if the committee is able to put the focus squarely on the Prime Minister, then instead of this becoming about we writ large and the kind of investigation that Mr. Turnbull has, you know, rightly mentioned has been pursued at other committees, in fact, with more success than we've seen here. I mean, a number of the requests that are in this motion have already been made successfully at other committees. The sky didn't fall and the world didn't end. I frankly think, with the benefit of hindsight, although I have supported the motion all along, I think we could say if we had just passed the motion and heard from those witnesses that were willing to appear, we'd be a lot further along by now than we in fact are. And so, but, you know, putting the focus on the Prime Minister means making it about prorogation, not about like an on-off switch, prorogue or not prorogue, but why did he choose the timing that he did? Why did it follow immediately upon the resignation of the finance minister? Why didn't he give it several extra days to ensure that Parliament could get the additional sitting that were agreed to unanimously by all the members of the House? Those are good questions. Now, Mr. Turnbull has suggested that we don't need to explore any of those questions because the Conflict of Interest Commissioner has ruled that there was no conflict of interest for the Prime Minister. I wish he had also read the conclusions of the second report that the Conflict of Interest Commissioner filed at the same time. I'm sure members of the committee know that that report has to do with the role of Bill Morneau, who at that time, and through the entirety of the last Parliament, I think it's fair to say, was the Prime Minister's right-hand man. You know, I think there's clearly an affinity between them in terms of how they think about issues. Bill Morneau was trusted to lead many aspects of government because we know the importance of finances, and we know the importance of money, and we know that the person who's put in charge of that for the government is somebody who has the total trust of the Prime Minister. I can also tell you that many times during the pandemic, when there were negotiations between New Democrats and the Liberals, it was very clear that many things were going back to the Finance Minister. And that without the Finance Minister, in fact, often it was the Finance Minister cited above the Prime Minister in terms of whose sign-off was really needed. And I think there were some good things that didn't happen, as a matter of fact, as a result of that particular finance minister's involvement. One of the things that didn't happen was getting students on CERB at a rate of $2,000 a month. One of the reasons why was because there was going to be this great new jobs program that was going to help top up the lower CERB rate under the CESB that students received. So that was a great idea that came out of the Department of Finance and Minister Morneau, among others. And those extra jobs and that extra funding never came to pass because a scandal developed. How did the scandal develop? Well, it had a lot to do with the involvement of the Minister of Finance, who incidentally, as was admitted in Mr. Turnbull's earlier intervention, was found to have breached the Conflict of Interest Act on 3 separate counts. So the idea that somehow the Prime Minister isn't politically responsible for that kind of mismanagement by his own government, I think is wrong. I accept the finding that there was no personal conflict of interest in the case of the Prime Minister, but that doesn't mean that there's no political accountability. And I think this ties actually back to what I would say is a mistaken conception of responsible government on the part of Ms. Shanahan, which is to say that political accountability is not the same as a narrowly defined legal sense of accountability. And so that's why we have a parliament. That's why we don't just leave it to the courts. If the only way that people could fail in political leadership was according to the law, then we would hardly need a parliament. For the accountability function. We might still have a parliament to kind of, supplement the legislative intentions of a government and challenge some of the legislative initiatives that they intend to move forward with. But in terms of accountability, we would just leave that to the courts. Now, I think that would be a deficient system because it would fail to capture a lot of really important things. And yet we see, and this is something that we've seen develop over many decades. It used to be the case that if you had a serious case of mismanagement under a file, you would see ministers take individual responsibility for that. And individual responsibility for that most often would look like a resignation. And that would happen when things went really wrong with a government, or if a government took a position that somebody seriously disagreed with. It used to be that you would more frequently see the resignation of individual ministers, and you don't really see that anymore. And so instead, there's more of an emphasis on collective responsibility, but somehow the guy at the top doesn't bear responsibility. So it becomes quite unclear actually who's responsible for the bad decisions of government. When Bill Morneau left, although I truly believe that he left not to pursue, a new executive position with an international organization, but that he left because of the way he had mishandled the We Charity file. When he left, he didn't take responsibility for it, though. I mean, you saw that again. The failure of a minister to accept individual responsibility beyond the collective responsibility. So as it is, I mean, on the Liberals' own telling, nobody has accepted responsibility for the We Charity scandal. There's been no minister that's left government as a result of that scandal. That's what I hear from Liberal colleagues anyway. If that's not true, I'd love to hear it. I'd love to hear that Bill Morneau left because he mismanaged the We Charity scandal and they recognize that there's a problem and he's accepted responsibility for that. And that's the reason his political career ended. But I haven't heard that. I heard he was off chasing a job for the OECD, which he quietly announced a little while later to no one's surprise, except maybe some Liberal Party faithful, that he was abandoning that pursuit. So we are in this awkward situation where there was a major mismanagement of a big file that had serious material consequences for thousands and thousands of Canadians who were registered as students that really ought to have seen themselves rolled into the CERB program, but instead were offered a discounted program on the promise of jobs that never came because the finance minister who did breach 3 sections of the Conflict of Interest Act in terms of his own conduct on this file, mucked it up. He made a political mess of what should have been a straightforward aid to students, particularly in light of the fact that the government already runs the Summer Jobs Program, which is a perfectly acceptable way to provide employment to students. It was never clear why a third-party organization was required when the infrastructure for administering Canada Summer Jobs is already there and could have been supplemented instead. So, excuse me if I think it's too much to call coincidence the fact that the finance minister appeared at committee, wrote a $40,000 check to We on the night before because he suddenly remembered that he owed 40 grand to an organization, which is not the experience of most people. Most people I know, if they've got a $40,000 debt, are very aware of it, and they don't have the ability to write it off in an evening as an afterthought off the side of their desk. And I think that showed to a lot of Canadians just how out of touch one of the principal decision makers in Justin Trudeau's government really was. And I think that was unbearable and he had to go. And that just happened to coincide with a prorogation. So yes, a pandemic can be a reason to prorogue Parliament, but the timing but look, I mean, Mr. Turnbull acts as if this is some kind of terrible surprise. I've said this before. In fact, he's repeatedly misquoted my attempt to say that before, and he likes to bring it up, where I've tried to indicate that there can be more than one reason, that the pandemic may have been important in the decision to prorogue, But there are many of us who feel that the timing and the nature of that prorogation, which unilaterally busted up a consensus in Parliament to meet 4 times over the summer, had everything to do with the We Charity scandal and getting out of political accountability for the We Charity scandal. And political accountability and legal accountability are not the same thing. And if there was an opportunity to see some political accountability over the We Charity scandal, it would have come if Bill Morneau would have fessed up in terms of his real reasons for leaving government. But he didn't do that. And so we're still in this place where there hasn't been any political accountability for a major mess up by the government that had real material consequences for a lot of students from coast to coast to coast. So yeah, I've been happy to support Ms. Vecchio's motion. I continue to be happy to support Ms. Vecchio's motion. But I also recognize that there's an imperative to get on with studying C19. Why is it important to study C19? It's important to study C19 so that hopefully we can make some changes to the way elections unfold before the summer. Because it's very likely that the Prime Minister, just as he used his special prerogative for prorogation last summer in order, I think, to further his political interests, which incidentally aren't covered by the Conflict of Interest Commissioner's report because they're out of scope by law, and that's fine, as they should be. We're not asking the Conflict of Interest Commissioner to weigh in on questions of political accountability. That's what Parliament is for. But last summer, the Prime Minister used his special prerogatives to prorogue Parliament at a time that was in his political interest. And we're now coming up against a summer where there's some real suspicion that he is going to use a similar special prerogative to call an election because it furthers his personal political interests and the political interests of his party, even though Canadians don't want an election. All we would like the Prime Minister to say is that if we get to the end of June without his government losing a confidence vote, that he's not going to call an election in the summer. He won't say that. He won't say that. And the question is, how can Parliament not be working in the summer when it's not meeting? So it seems to me that a Prime Minister that was really interested in listening to Canadians who overwhelmingly are not interested in having an election right now would be willing to say, if the opposition gets us to the end of the Parliament in June without triggering an election themselves, I'll be happy to do my part and not trigger an election until Parliament resumes and we see how it goes after people have had a summer.
Just enough for one bath or shower.
I know, Peter.
You're not
often
you're not on mute, Peter. Okay.
I'm sorry about that.
Talking about the Prime Minister's behavior often makes me want to shower as well, Peter. So I appreciate your contribution, and I take it as being quite on theme. But relevance is a rarity here on that committee. So it's because of the fact that there are questions as to the way in which the Prime Minister exercises the special prerogatives of his office that we need to have a timely study of C19. If the Prime Minister would just say that he's not going to call an election during the summer, then we got lots of time to study C19. It's not a problem. We could study it over the summer, and we could have something that the House could be prepared to vote on in the fall. The urgency for studying C19 comes directly as a result of the behavior of our Prime Minister. And I put to you that it's a false sense of urgency. Canada does not require an election this summer. There shouldn't be an election this summer. Canadians don't want an election this summer. All of the opposition leaders have pledged not to trigger an election before the summer because they've all pledged not to trigger an election during the pandemic. So certainly, if we can get through these next 5 weeks without the opposition parties voting non-confidence, there could be no reason for the Prime Minister to decide to trigger an election in the summer other than because he considers it to be in his own political interest. Because the opposition parties can't obstruct a Parliament that's not meeting. If there's a way to do that, why don't you let me know? I'm looking at Mr. Turnbull there because it seems to me that if Parliament's not meeting, opposition members can't obstruct it. And so it seems to me that it would be perfectly reasonable for the Prime Minister to say, if we get to the point where Parliament's not meeting, then I'm not going to be the one to call an election. We can't get that. That's where the sense of urgency comes from C19. So I think that it would be a mistake to simply move on from this study. I do think that we need to get to the point where we report back to the House. I mean, look, PROC has spent a completely disproportionate amount of time debating how to proceed with this study. I think it would be an awful shame if we didn't report anything back to the House on that. So simply moving on to the study of C19 and not coming to some kind of agreement as a committee on how we might proceed, I think is a mistake. And I recognize that it's challenging. I know that, you know, government members have dug in on various positions over the course of the debate. And I recognize that opposition parties don't always agree, and that it can be difficult to carve a path forward, if you will. That was something that I mentioned last day in the context of committing to try to do that, as the other parties did. And we did indeed meet to try and find that way forward. And again, I mean, you know, we've seen what can happen to a committee just when the interests of one political organization are at play. We've been going through, you know, dozens of hours of debate because Liberals don't want to have a vote on the motion that was put forward, despite the fact that there seems to be a majority consensus on the committee in order to move forward in the way proposed in Ms. Vecchio's motion. So then you try and take three different political organizations with different goals and different thoughts about where to go and how to do it. And that discussion certainly can become quite difficult as well. But we have been having that conversation over some time, because I don't think anybody wants to hold up, and I don't want to speak for anyone, but certainly my impression in the discussion with the other parties is that I don't detect a real desire to be holding up the study of C19, but I did also hear loud and clear that there needs to be some kind of resolution to this study. I want to remind Liberal members on the committee that you know, the reason that we're in this study is because of a mechanism that the Prime Minister brought forward. It, as members here have heard me say before, it's not my preferred method for how to deal with questions of prorogation or even dissolution. And again, I mean, I think those are very related powers. I think they should be dealt with in a related way. And I think that the best way that, you know, that's not outlandish or coming from nowhere. In fact, you know, the United Kingdom, which is our model, or where our model of Westminster parliamentary democracy comes from, has adopted a provision so that it's actually Parliament that makes decisions about prorogation and dissolution. And unfortunately, that more democratic way of navigating the questions of dissolution and prorogation isn't something that has yet come to Canada. And and there are some reasons why it's more difficult to implement in Canada. But like many politically difficult situations, provided that there's adequate supply of political will, there's usually a solution. And so, you know, when it comes to prorogation, for instance, I've heard that Canada may even need to go so far as having a constitutional amendment in order to allow the House of Commons to make a decision about prorogation, as opposed to leaving it uniquely up to the Prime Minister. There have been some really interesting witnesses here. I think of Hugo Cyr, for instance, who is here to talk about prorogation, who have proposed essentially workarounds in recognition of the fact that by convention, it seems to be a constitutional power of the Prime Minister, and therefore needing some kind of constitution level intervention in order to change the way in which that prerogative would be exercised. So again, I mean, I think the best way to deal with prorogation that would get us around the need to even have this study, because we would have a fulsome debate in the House of Commons and then a decision by elected members of our parliament on whether to prorogue or to dissolve earlier than a fixed election date. I think that's the gold standard. But that's not the one the Prime Minister chose. What did the Prime Minister choose? The Prime Minister chose to say that the government would table reasons for the prorogation and that those would be deemed referred to PROC. Now, presumably, that didn't mean let's refer them to PROC so that, you know, PROC can use the file as a doorstop. It was, as is often the case when things are deemed referred to a committee, for the purpose of study, just as the estimates are typically deemed referred, and committees typically deal with them if they're a well-functioning committee that isn't held up in filibuster over what is a pretty straightforward motion. So that was the Prime Minister's solution, and that's why we're here. So yes, Liberals did agree to have a study of prorogation. I take that to mean that they agreed to honor the Prime Minister's intent when he said that political abuses of prorogation are real. And I think he recognized in that proposal the political dimension of accountability. That is to say, the dimension of accountability that goes above and beyond strictly speaking legal questions of the kind that a conflict of interest commissioner might rule on, for instance. And so here we are, and we're undertaking that study, and we're undertaking it for the first time ever, which means, and I say with some measure of embarrassment, as not individually, but as a member of this committee, that when people look back to the founding study at PROC on reasons for prorogation in some future instance where a Prime Minister is alleged to have prorogued for political reasons above other kinds of, let's say, more altruistic reasons. So political reasons in the pejorative sense. There can be political reasons in a good sense as well. And some of those may have been at play with respect to the pandemic, but I think they were used as cover for some other kinds of political motivation. Fair enough. Let's get the guy in here. Let's talk to him about it. That's the whole point, after all. So here we are, and this has been the kind of launch, if you will, of Prime Minister Trudeau's idea about how to stem political abuses of prorogation. I don't think it's gone very well, but I don't think it's beyond redemption. I think it was very good until the filibuster started. We heard from people that we ought to hear from. I'd have been happy not to have heard from the government House Leader, though, and go straight to the Prime Minister, because as I say, it was very clearly a decision for him to make, and that he did make. So we did all of that, and it was going very well. And then there were some, I think reasonable proposals for other witnesses that have to do with some of the alleged reasons for prorogation. And suddenly that wasn't acceptable to the government, so here we were stuck in a filibuster. I think it's really important in terms of setting a good precedent that the Prime Minister appear. I think it's even more important that the upshot of this entire process not be that PROC fails to report back, and that the Prime Minister uses a similar special prerogative to end the Parliament before PROC ever has a chance to report back. That would also be a really bad precedent, to say that these reasons are going to be flipped to PROC. They might start to study it. They might hear from some good voices, then descend into a completely unproductive months-long period of debate and never emerge. I think that would send the wrong message. I would hope that, if the Prime Minister or some of his folks are listening, or some Liberals on the committee that report back, that there would be some sense of duty to this proposed solution, so that we don't end up in a place where we don't even bother reporting back. How sad would that be? And so that's why I do think it's incumbent upon us to work towards some kind of resolution to what has been a very frustrating ordeal. And as I say, I mean, that's why members of the opposition parties have been discussing what a way forward might look like. But of course, it's an odd position of reverse onus where somehow, you know, I've been part of opposition filibusters. Usually we take it to mean, like if you're in an opposition filibuster, usually you see it as your own responsibility to find a way out of the filibuster. Now, with, you know, respect to Mr. Turnbull for having tried, it didn't really work. We haven't seen, you know, a lot of flexibility in terms of what the government might be prepared to accept or not accept. We had an up and down offer from Mr. Turnbull. I'm appreciative of the fact that we finally got to vote on that. I think that was good. As I say, it kind of clears the space for trying to find some other kind of alternative. And we may have to cycle through several attempts. So I would say that if we can get into a place where we're proposing things and dealing with them without having to debate each proposal for months at a time, I think the committee would be well served. I think this special mechanism of the Prime Minister would be well served, because it might actually get us to a point where we break the impasse. If the model is that we're waiting on some one person to propose some one solution that's automatically going to rally everyone, and if it doesn't, we're stuck in a month-long filibuster, we don't have enough time to make that model work. Arguably, even if we had another 2 years, we might not have enough time to make that model work. And I'm just, you know, basing that on the precedent that we've already set with the length of time that we spent considering Mr. Turnbull's amendment. So that all gets somewhat, it gets hard to do. So I would definitely encourage, as we work through these things, to try and have a spirit of voting, you know, within a few meetings on any one proposal, so that if it's not the one that's going to do it, we can dispense with it and move on and hear some other proposal. I think that might be a nice way to kind of break the deadlock, because there's definitely going to have to be some deadlock breaking at this table, it seems to me. I don't know that we're going to, as I say, be able to negotiate something, you know, behind the scenes that brings everyone aboard all at once. So the rhythm of the committee has to change, because it's been quite slow. And we need to move from what we've been doing in a couple months to doing in a couple meetings. And certainly, you know, I'm willing to make some proposals and not take their passage or failure personally. I think, you know, one is always disappointed if you make a proposal towards resolution and it doesn't pass, at least in the sense that you were hopeful for a resolution. But I would rather know that something that I propose isn't going to work within a couple meetings than to have to take a couple months to get to a rather obvious conclusion. I'm wishing I had poured myself a water, Madam Chair, but hindsight is 20/20, as you know. In any event, I do now want to propose something that I know, you know, may not be that thing that everybody suddenly goes, that's amazing, I love it. Obviously, why didn't we all think of this months ago? But I do want to throw it out there as something for consideration. And I would urge members to take a reflective approach to the proposal. I do think that there are advantages and disadvantages for all in this proposal. And yeah, certainly don't want to be causing any knee-jerk reactions, but you know, we don't have a full formal, I think it's fair to say, and you know, other opposition members can correct me if I'm wrong, I don't think we have a fully formed three-party proposal that's going to come forward today. So I'm going to put something out there that I think probably won't be shocking to anyone, but with an adequate period of reflection, I think may be the solution. And if it's not, then perhaps we could vote on it next day and dispense with it if it's not the way forward, so that the table can be clear for somebody else to put something forward. Maybe in the meantime, there will be some discussions that help shepherd us all towards a common solution. I would certainly invite that and be happy to talk to people about what that might look like if it's not the thing that I'm going to propose. So what I would like to propose is an amendment to Ms. Vecchio's motion. And I would move that the motion of Karen Vecchio concerning the committee's study of the government's reasons for the prorogation of Parliament in August 2020 be amended by 1, replacing paragraph A with the following. A, renew the invitation issued to the Prime Minister to appear before the committee, provided that if he does not agree within 1 week of the adoption of this motion to appear for at least 1 hour, the chair shall be instructed to report to the House forthwith a recommendation that this committee be empowered to order his appearance from time to time. And 2, by deleting paragraphs B through H. I'm going to read that one more time, but in French, Madam Chair, for the sake of Francophone members of the committee. Que la motion de Karen Vecchio.
That Karen Vecchio's motion in respect of the committee's study of the government's reasons for the prorogation of Parliament in August 2020 be amended by 1, replacing paragraph A with the following. Renew the invitation issued to the Prime Minister to appear before the committee, provided that if he does not agree within 1 week of the adoption of this motion to appear for at least 1 hour, the chair shall be instructed to report to the House forthwith a recommendation that this committee be empowered to order his appearance from time to time, and 2, that paragraphs B through to H be deleted.
I am going to just send that to the clerk so that he has the language and it can be circulated to the committee, Madam Chair. And I want to talk a little bit to what I think are some of the advantages of this proposal. One of the things that we have heard loud and clear at this table many times is that the government takes exception to the idea that the Procedure and House Affairs Committee would be, for lack of a better term, and I'm not sure I like this term, but relitigating the We Charity scandal in the way that it has been dealt with at other committees. We've heard that very clearly. That's something that I'm prepared to do because I still think that there's a dearth of answers. And as I say, I don't think that the government has really adequately had the kind of, or been held to the kind of political accountability that I think the We Charity scandal demands. So, you know, that's why I've been very happy and comfortable supporting Ms. Vecchio's motion. But I do hear that the government doesn't want to do that. For me, the question about the We Charity scandal in the context of this study isn't about all of the details of the We Charity scandal. And we have seen the Ethics Committee deal with a number of those questions and hear a number of the witnesses that were in Ms. Vecchio's motion. Rather, for me, the interest of the We Charity scandal, as I say, has to do with the timing, the length, the nature of the prorogation that the Prime Minister in fact executed. Why did he prorogue on the day that he did? Why did he cancel a unanimous decision of Parliament to have 4 summer sittings? Why did he not heed calls by at least some opposition parties, I'll speak for the NDP here, by us, to resume earlier in order to have some time for parliamentary dialogue about the replacement of CERB? These are all important questions. And I think that the details of the We Charity scandal do bear on those issues. So I do want to talk to the Prime Minister about those things. But, you know, do I need to talk to the Deputy Minister and the Minister of Finance and the Minister of Diversity and Inclusion and Youth, even though a lot of the parliamentary dialogue, certainly a lot of the media conversation and evidence points to their involvement in the way that the We Charity scandal unfolded. They aren't the decision makers when it comes to the timing and the nature of prorogation. And so I'm satisfied that while I would like to hear from them here, and while I think their interventions may have some light to shed on how things happened, I don't need to hear from them in the same way in a study that is on prorogation. If I had to prioritize one witness in the entire motion of Ms. Vecchio, the Prime Minister is clearly it. For political reasons, sure, in the best sense, which is that he was the decision maker. And the very kind of political accountability that Parliament is at least in part established to deliver rests with him. And he is the appropriate person to ask about those issues. I don't think I'm going to learn more about the nature of prorogation from the Minister of Diversity and Inclusion and Youth than I am from the government House leader. Those are two people that are part of a cabinet that the Prime Minister might have spoken to about the decision, but who aren't ultimately responsible for it. I do think that in the case of the Prime Minister, there's cause to believe that we might yet learn something, and that even if we don't learn something new, it will have been a valuable exercise, because that is how political as opposed to legal accountability operates. The decision makers have to answer questions about what they did and why they did it. Likewise, I think it would be very interesting to hear from Mr. Morneau about what his reasons for resigning were and why he thinks that his resignation happened, I dare say precipitated, but I won't use that kind of prejudicial language. But it did happen like right before prorogation. Does Bill Morneau think that there's a link between those two things? I'd love to hear it. I'd love to hear whether he thinks so or not. But the point would remain that it wasn't Bill Morneau who decided to prorogue Parliament. It wasn't Bill Morneau who went down to the Governor General's residence when he did, because he didn't, the Prime Minister did, and made that call. It would be useful to hear from Katie Telford, who I'm sure was involved in the decisions that led up to the Prime Minister exercising his special prerogative in the way that he did. Is it strictly necessary in order to better understand prorogation? Not anywhere near to the same degree as the Prime Minister. The Kielburgers clearly had something to do with We Charity and had a role to play in the proposal that We Charity was pursuing with the government, and who had some of those relationships with government that landed Bill Morneau in a conflict of interest. But did they decide when Parliament would be prorogued? No, they didn't. They didn't decide that. Only one person can decide that. It's the Prime Minister. So in a study of prorogation, who is it most important to hear from? Out of all these witnesses, it's the Prime Minister. There's no big surprise here, Madam Chair, but I think it's important to reinforce. Like, I recognize that the Kielburgers weren't the ones who made that decision. Now, does that mean that by saying we're going to limit the scope of this motion, that there will be no questions about we for the Prime Minister? Absolutely not. But if the Prime Minister appears, those questions will be properly directed at the decision maker about prorogation, and they can be asked in a way that gets to the bottom, not just of the fact of prorogation, which, you know, obviously happened and is obviously a prerogative of the Prime Minister to prorogue. Nobody's ever disputed that. The question is in how has he used that prerogative, and is he using it appropriately? And there you have to get into the details of the actual prorogation. So while many of these witnesses can help us get into the details of something that I think still calls for answers, that is the We Charity scandal itself, they can't give us any kind of privileged information or insight into the nature of the prorogation. The same would go for the Pearl Muters, who again have testified at other committees that were looking directly, and rightly so, and I'm glad for their work. And I'm grateful to Charlie Angus for the leadership that he showed in that study and the work that he did along the lines of holding the government politically to account for what was a serious scandal. But I don't think that the Pearl Muters are going to have a lot of insight into the nature of prorogation. So again, while I think it would be helpful to hear from many of the witnesses in this motion in order to better understand the We Charity scandal, which might help us better understand some of the motivations of the Prime Minister, if we're looking to try and wrap up this study now on an expeditious basis after spending a lot of time on it, I don't think that they're the one witness that we need to hear from in order to get that work done. Likewise, there was a call for the production of a lot of papers that I think ought to be produced, papers that I think would give more insight into the We Charity scandal that Canadians deserve to hear. But those papers are not going to shed light on the question of why the Prime Minister decided to prorogue Parliament the day after the resignation of his finance minister, which apparently had nothing to do with the We Charity scandal, or his, at that time, very recent appearance before another committee of the House, where he was held to account for the fact that, he actually had a debt to the organization that was being sole source for a large government contract of $40,000 that he had only cleared the night before. Like, we're really supposed to believe that none of these things are connected? And I'm sorry, Madam Chair, that's just not. I wouldn't be doing my job if I accepted such a facile explanation. And so even all those things considered, there's still the question, as I say, I mean, when you consider all of the needs of the pandemic and the desire, I think, of many government backbenchers to spend some time consulting with their constituents on what might be in a speech from the throne. Although I would note, Madam Speaker, we only had one scheduled sitting over the time of that prorogation. Now, that one scheduled sitting also happened to coincide with a deadline for documents like the ones called for in this very motion that we've been debating. And the prorogation, if we do what my Liberal colleagues asked us to do and believe that it's a coincidence, coincidentally, the timing of the prorogation just happened to rub up against the deadline where documents like the ones in this motion were actually due, that the government clearly doesn't want to provide. Again, I mean, we have this odd coincidence about the timing and the nature of that prorogation, how long it lasted, and what the effects of proroguing at that exact moment on the heels of the resignation of the finance minister after an embarrassing testimony on the We Charity scandal, and on the eve of an important deadline for the tabling of documents that would lay out many details about that scandal. And despite the recent finding that the Prime Minister wasn't in a legal conflict of interest, what we do know is that his right-hand man was, and we know that political accountability has a broader application than legal accountability, and that the Prime Minister does share in the political blame for this fiasco that even the finance minister refuses to take responsibility for. And if he has taken responsibility for it somewhere, then I would urge my colleagues to point us in the direction of where that actually happened, because I haven't seen it yet. In fact, I think the predominating quote in response to inquiries about the recent conflict of interest report by the former finance minister, Mr. Morneau, is no comment, I think, has been what I've seen. If he's commented more extensively on that, it's I haven't seen it. I might have seen something that was it was a prepared statement that was to the effect of, well, that's in the past, it doesn't matter anymore. Of course, we all remember Rafiki's compelling refutation to Simba in The Lion King of the claim that actions of the past don't matter anymore. Just trying to generate some interest on the committee, Madam Chair. I was beginning to suspect I might be losing interest, so I thought maybe a Lion King reference would spice things up. But it's a tough crowd, and I appreciate that. I appreciate the reasons for that. So, you know, what am I saying? What I'm saying is that this particular amendment offers, I think, a real and significant olive branch to members of the Liberal Party on the committee who have spent a lot of time telling us how irrelevant many of the witnesses are. And while I don't agree with them in that assessment, what I'm offering here is to actually dispense with all of that. And not only are we dispensing, am I dispensing with that or proposing that the committee do, I'm also reducing the amount of time that the Prime Minister would have to appear from 3 hours to 1. So essentially, everything that Liberal members of this committee found objectionable in the other motion disappears, except for 1 hour of the Prime Minister appearing. And that's, I think, pretty good, because if you were to make a list of what the Liberals didn't like about this motion, to have everything off the list except for one thing, and to have the length of that presentation be reduced by 2/3 is a pretty good offer, I think. And I won't speak for the other parties on this, but what I will say is I do think that I'm not alone in feeling that it is very important that the Prime Minister appear in this study. I won't be alone in asking some questions about the We Charity scandal in that hour either. But my questions will certainly revolve around the circumstances of the prorogation as I see them mattering to Canadians who were concerned while on CERB about having a better sense of what was waiting for them on October 1st. And having then participated in the rush debate that occurred at the end of September in Ottawa, I can tell you that that would have been time well spent. Having heard from tons of Canadians from coast to coast to coast in the lead up to that deadline about the anxiety and the uncertainty that they faced, I can tell you that it would have been productive to create more space for Parliament to hash out what the agreed upon way forward at the end of CERB would have been. Having heard from students who were very disappointed that the NDP's proposal for a student benefit was cut down and didn't match what was on CERB, and the fact that those extra jobs that were supposed to top up that income support didn't happen, I can tell you that this was a decision that is very real to a lot of Canadians and had an impact on them in a very difficult time. Folks on CERB ultimately did get an answer, and we were ultimately able to maintain, the NDP were able to maintain the benefit level because the government was looking even last summer at cutting the benefit level, and we were able to avoid that. I was happy for that. Students, on the other hand, never did see that income that they lost made up. And when you're a worker and the only thing you have to sell is your time, that kind of lost time really matters, and it's not that easy to bounce back from. There's no extra check coming for the time that they couldn't spend working and getting paid a wage. So that's why this continues to be a very relevant matter. And I think that this, again, and I would just say, like, I know that this is not going to be something totally new. I know that, I don't know that any committee member is going to get particularly excited at the proposal, but in my experience, that's usually a sign that there's some kind of meaningful compromise afoot, is that nobody's particularly overjoyed. And I can tell the committee that I share that feeling in respect of this amendment, but I do think it's a way forward. And what we clearly need is a way forward. Before the constituency week, we were building some momentum to a way forward. And I appreciated that Liberal members of the committee allowed us to have a vote on the amendment that had been before us for a very long time, to clear the way to have a discussion about another proposed solution. I think given the fact that we spent months on the last solution, it would make sense to spend at least this meeting on the current solution. And I'm quite open to having a vote on it at the next meeting. I think that might be useful. If folks want to talk about it a little bit more, I'm obviously happy to do that. But if this isn't going to be the one to do it, which I hope nobody will decide today, because I think in these kinds of delicate conversations, time for reflection is important, then I do think that we can try and dispense with it relatively quickly next day or some subsequent meeting after that in the not too distant future. Because what I'm trying to honor here is what I perceive as an important need, both to conclude this study. I really think it's important that we report back to the House somehow. And I'm satisfied that if we hear from the Prime Minister, we can at least report back. I think that's something that we can get done. I think that's worth an hour of the Prime Minister's time. I think it would be worth it anyway. I frankly think that there's a duty here as the decision maker to appear, but it's a double duty because I think he also has a duty to honor what he proposes the solution to potentially abusive political abuses of the power prorogation. And what he proposed was that decision makers answer for that. And of course, he is the decision maker. So that's important. And I think that allows us to get on and conclude this study and report something back before the end of June, which I think is very important to do so that when people look back on this, and I appreciate that, clearly Liberal members feel that there was no political abuse, either in the fact of having prorogation or apparently even in the details of the prorogation, the nature, the length, the timing. Fine. But that doesn't mean that at some future point they aren't going to suspect another prime minister of having abused that political power to prorogue Parliament. Indeed, I think I can find some common ground anyway with Liberal members on the committee of past abuses of prorogation. So the question then becomes, what do we think is a good process for how to introduce some meaningful political accountability into that? And I think having some written reasons tabled and forwarded on to PROC, who hears from some academics and then just kind of buries it as a testimony item rather than reporting back to the House, would be a mistake. And I think that's what we're at risk of doing if we don't find a way to wrap up this study. And I think the quickest and most straightforward way of doing that is to have that opportunity for political accountability with an appearance by the Prime Minister. That allows us to move on quickly if the Prime Minister is prepared to do that in the spirit of his own solution. The other reason why it's important to try and find some kind of conclusion to this is because I do want to see us get on to the study of C19. I do want to see C19 sent back to the House with enough time for it to pass before summer. And, to be very clear again, I want that because I don't trust the Prime Minister not to call an election during the summer. If the Prime Minister would do one of two things, it would help the situation at the committee a lot. If the Prime Minister would appear, I think this would reasonably resolve our issues here at the committee. If the Prime Minister would say that he's not going to call an election during the summer months when Parliament isn't meeting, then that would give us more time to consider C19 and again, help the work of the committee. And I guess what I'm trying to say is that it's an odd scenario to have government members filibustering a committee with an expectation that the opposition is going to help them break their own filibuster. As I say, in filibusters that I've been engaged in before, we talk about what our end game is and we talk about how to get out of it if it's not producing what we want. Because we recognize that people who start a filibuster are the people who have the obligation to finish it. And so we're in this odd moment where I think government members are trying to shift the onus onto the opposition to break their filibuster. They can break it at any time. I'm not the one, with the exception of, a longer intervention today, and I appreciate the patience and interest of members of the committee with my intervention today. I'm not the one who's been filibustering for the last number of months. So it's not for me to I can't end the filibuster just by stopping talking, which is normally the power of somebody who's engaged in a filibuster. And it's normally up to that person who has the power to end it by stopping to find a way forward. So it's a very odd position to be in, having colleagues, imply that somehow it's the responsibility of the other side of the table to find a way out of their own filibuster so that we can consider their own legislation. I mean, I hope that Canadians who are listening appreciate what an unlikely and broken kind of situation this really is. I've done my best in good faith to try and bring about an end to this filibuster on a number of occasions. But it's true that I have not been willing to compromise on the importance of getting the Prime Minister here, because I think there are significant, because I believe there are some really important non-partisan parliamentary reasons for having the Prime Minister at this committee. And I'm not really prepared to bend on those. But this amendment brings us a long way toward getting rid of what government members found most offensive, if you take them at their own word, and we should here, in the motion. In fact, I think just prior to my own intervention, it was Mr. Turnbull's contention that, one of the things that was so objectionable about the motion was this litany of witnesses and documents. And so, with this amendment, that's gone. It's a request for the Prime Minister to appear for an hour. All of the additional stuff that government members have said are a fishing expedition, that have nothing to do with prorogation, all of that is done. All of that's gone with this amendment if it passes. So this is a real opportunity for government members to be able to take out of the motion the lion's share. And I'm talking like everything but 1 hour with the Prime Minister. All of the witnesses that are only being called because they have a connection to we, but don't have a clear connection to prorogation except through we. And so we hear that Liberal members aren't interested in exploring those connections, even though I think those are connections that ought to be explored. So we take them off the table. And the only call here is for the principal decision maker in respect of prorogation, which is, of course, what we are studying. How do we know he's the principal decision maker? Because you can go back to 1935 when Cabinet said by special proclamation that those decisions, the decisions around prorogation and dissolution, rest with the Prime Minister alone as a special prerogative. That is to say, different than many of the other prerogatives of his office that he often jointly exercises with Cabinet. It's not to say there wasn't a discussion at the Cabinet table, but it is to say that at the end of the day, he is the sole decision maker. It's why the NDP has asked the Prime Minister, not the Deputy Prime Minister, not the Minister of Diversity, Inclusion of Youth and Youth, not the Minister of Finance, not anybody else. We've asked the Prime Minister to commit to not calling an election during the summer, because we recognize it is a special prerogative of the Prime Ministers to make that call or not. We haven't asked that question to any other member of Cabinet. Why? Because no other member of Cabinet makes that decision, and Cabinet does not make that decision collectively. It's the Prime Minister that does it. So as I say, I mean, we've heard many things about how far-reaching the motion was, what a fishing expedition it was, how we should be talking about prorogation and not going down rabbit holes. And while I say to my honorable colleagues on the other side, I don't agree with that analysis of the motion, for the sake of having 5 weeks left, and in the context of a Prime Minister who won't commit to not calling an election during the summer, we need to get on to C-19. We need to do it in a way that, above all, sees this committee report back on the issue of prorogation, not for the reasons of this Parliament, but for the reason of future parliaments, which is, what presumably the Prime Minister wanted when he pursued a change to the standing orders, because he recognizes that the prerogative of prorogation is sometimes abused. And he wanted a mechanism in order to create the context for political accountability. And I think if the Prime Minister really is comfortable in his reasons for having prorogued when and how he did, then he ought to be willing to come here to PROC for an hour to allow the work of a senior committee of Parliament to continue, particularly in light of the fact that our next bill and the consideration of that bill it's a bill of his own government, and it's a bill that has a sense of urgency attached to it because of the way that he carries himself in respect of a special prerogative, just like the one that we're studying. When it comes to proroguing Parliament and dissolving Parliament, the power is the same. It rests uniquely with the Prime Minister. C-19 is urgent because he refuses to say that we're not going to have an election during the summer. And that has everything to do with his exercise of the prerogative that's at issue in the report that we're doing. So, like I say, with no pretension that this is a perfect solution or that it's going to satisfy everybody. In fact, I think it will be dissatisfying to all of us in some way, shape, or form, but it might be the way that we can move forward on this. And before anybody, makes any hasty decisions, like I say, I think it's important to have some time for reflection. I think it's important to have time for news of this proposal to work its way up to the Prime Minister and the people around them so that they at least have an opportunity to consider whether they think this is worth it. Because I do think that the way out of this quagmire is through prime ministerial leadership. And while I may have my own doubts about how on supply that really is, I want the opportunity to be proven wrong in what I think about the Prime Minister, and for him to have the opportunity to come to this committee for an hour and explain his reasons for prorogation so we can file our report and we can move on. So my proposal to you, Madam Chair, seeing that we happen to be at our normal ending time for meetings, I know my Liberal colleagues are great believers in coincidences, so this is just one more for them to believe. I would propose that we adjourn or suspend our meeting at the normal time so that we can come back on Thursday at 11 o'clock. And perhaps by then, people will have a sense of where they would like the debate on this particular amendment to go. And if at that time members would like to have a vote so that we can dispense with it, that would be great. And with that, I'll cede the floor. Thank you.
Thank you, Mr. Blakey. I believe your remarks just miraculously ended at the right point in time. And if I have consensus from the committee, we can suspend for today. Okay, seeing that there's no one who said no, we are suspended.